Great. We'll go on the record in the state of Wisconsin versus ELIAV Goldman. It's 26 CF 763 appearances.
The state appears by ADA Ben Wagner.
Good afternoon, Your Honor. Jason Luzak appears with ELIAV Goldman, who appears in custody.
Great. And do you have a copy of the criminal complaint?
I do. I acknowledge receipt and waive its formal reading, reserving the right to file a motion to dismiss challenging the probable cause in the complaint and any jurisdictional challenges.
Right. And do we have a good address on the complaint?
That's your current address. Yes, it is.
All right. Well, for purposes of today, I'll make a finding of probable cause. There's a public safety assessment report. It recommends a signature bond. I don't know if you received a copy of that. If not,
I did. I just received it.
Okay.
Yes.
What's the state's position on bail?
The state is asking for $20,000 cash bail, as well as the conditions that the defendant not have any unsupervised contact with children, that he have no contact with child V is listed in the complaint, as well as her family, and that he be banned from the Orchard Ridge neighborhood, which is bordered by Raymond Road, Whitney Way, US Highway 12 and 18, and requesting that that he be banned from Memorial High School, Toki Middle School, and the MYArts Children's Theater. These are extremely serious allegations in which this child victim was 15 years old. The defendant is 29. They had met during the victim's 8th grade year. Throughout an investigation, it uncovered 130,000 text exchanges between the two, with close to 20,000 texts in March of 2026 alone. It appears there was pressure for the victim to see the defendant outside of work. These are, again, extremely concerning allegations. The state does have a strong case. I think that significant cash is warranted here. I understand that the defendant doesn't have any criminal history, but I believe that these are Act 3 eligible offenses. And I think that cash bail is necessary in order to protect the public, especially the child victim involved here.
All right, and the defense position?
Thank you, Your Honor. I believe that the assessment report got it right, that a signature bond is appropriate in this case. Mr. Goldman knew of the allegations on March 20th. He went nowhere. He actually hired counsel immediately. He appears here and intends on following all the conditions of bail, which I think addresses the concerns that the state has addressed. Obviously, we have a very different version of the facts, and today is not the day to resolve those issues. He is presumed innocent of these charges, and he has ties to this community, deep ties to this community. He's retained counsel immediately, has no criminal record. He knew about a Title IX investigation that was going on March 24th. He stayed here to address those. He's not going anywhere, and I think a signature bond is appropriate in this case.
Right, and any response?
No, Your Honor.
All right, and I guess when I was looking at the case in preparation, I had to do a little investigating. I think the PSA report is correct that the grooming charge is Act 3 eligible. I'm not sure about the other charge. I didn't find anything with respect to the 94809-8 sub 2 charge. Does anybody have a position on whether that is an Act 3 eligible offense as well?
I did take a look at that prior to the hearing, and I do agree with the court. I think that the one is Act 3 eligible, but the other one would not be.
And
Yeah, that's my understanding.
Okay. I just wanted to make sure I was on the same page. Obviously, the grooming statute is a very new statute, and I had to find the text of the actual bill and sift through that, and it looked like they'd added that or were intending to add that to Chapter 969. All right. Well, I want to make a brief explanation about bail. Obviously, counsel are aware of this, but not everybody is. This isn't a sentence. He's been convicted of nothing. He may get convicted of nothing. This isn't where I mete out punishment. This is simply to set bail. One purpose in all cases is to assure appearance in court. I don't know that that's a significant factor for me here today. This was something that I think got a fair amount of media attention prior to him ever being arrested and contacted by law enforcement. As counsel notes, he was aware, was in the area, remained, hired counsel, didn't take off. So I don't think that's a factor where I feel like cash bail is necessary to assure his appearance in court. It's such a new statute. I don't really have a good sense as to what the potential sentence might be. But the penalties for the grooming charge are significant. But given his ties to the area, lack of prior criminal record, and essentially being aware of this and remaining in the area, I'm not convinced that high cash bail is necessary to assure appearance in court. Count 2, though, is an Act 3 eligible offense, and there I can set cash bail to protect the public. It's not a presumption just because it's an Act 3 offense. I have to take into account a number of factors. One of those is a history of prior violent charges. There is none. Obviously, he's got no record. That's certainly in the defendant's favor. I don't really see any affirmative defenses. Obviously, there's the defense that he didn't commit the crime or the state's not able to meet their burden of proof at trial. The other factor is the risk of flight. Again, I've kind of spoken to that. I don't think that that's a significant factor in my mind. And then we get to the intimidation or risk of intimidation. That's a more concerning factor for me. Obviously, there's been extreme amounts of contact that's alleged, very manipulative, who's in a position of power, and that that's reaching out to the victim and trying to find out what was said to law enforcement or school officials. That concerns me, that there's the potential for intimidation, violating bail conditions by contacting this particular victim. I'm supposed to set cash bail if I think it's necessary to protect the public in the least amount that's sufficient to do that. I do think there is a need for some cash bail here because of that particular factor. I don't think it needs to be on the level that the state has requested, which potentially would leave Mr. Goldman just sitting in jail until trial, and that's not necessarily the goal of Act 3, and certainly not appropriate in this particular case. I'm going to set cash bail at $5,000. I will order that you have no unsupervised contact, and it's just child victim. Did I hear that correctly? That's
Correct, Your Honor.
Identified. All right. Normally, I think we need something more descriptive, but I think given the sensitivities of this particular case, and it's pretty clear to me that Mr. Goldman should know who we're talking about. He nodded his head yes, and he's got counsel. I'm satisfied that he is aware of what he needs to abide by. And if he does have contact, it would be a knowing intentional violation of that condition. I will order a ban from the Orchard Ridge neighborhood. I'm not going to reiterate the boundaries. I think those were explained unless the clerk needs that repeated. All right. I'll order a ban from Memorial High School, Toki Middle School, and was it the MYArts Children Theater?
Yes, on 1055 East Mifflin Street.
All right. And then I'll order that he have no contact, direct or indirect, with any of child victims' immediate family members. Have I overlooked any of the non-monetary conditions, Attorney Wagner?
No, Your Honor.
Sure, I just had a question. I think there was a request to not have any unsupervised contact with any child. Are you just ordering that for the child?
And maybe I misheard it when it was stated. Did you ask for a blanket no contact with any minor children in addition to
Correct.
child victim? All right. And I guess I didn't hear any objection to that. It seems like an appropriate condition, but if there's some reason that that is a problem, let me know.
At this time, no, we don't have an objection to that.
All right, I'll order also that you have no contact, direct or indirect with any minors. And what about time limits for a preliminary hearing?
We'll waive them.
Okay, if you want to hang on, the clerk can let you know what we've got for a status date.
And Your Honor, I would just ask that the DA has a map that shows the exclusion zone, just so we're clear on that. I've shown that to my.
Do you have a copy that we?
I do have a copy that I showed defense counsel.
Indicated defendant shall not be in the Orchard Ridge neighborhood, which is bounded by Raymond Road, Whitney Way, and US Highway 12, 14, 18. I think that was as it was described in the request. Is it necessary to have a map submitted as well?
I think for clarity, well, I mean, I have a copy of the map, just so we're clear, so that there's a record. I've shown it to my client. He understands the bounds of it, but I just.
All right, well, I guess it's up to the lawyers as to how you want to prosecute your cases and whether you want that marked and put in the court record. I was willing to do it if that's something that you want to do, Attorney Wagner.
I think that the descriptor that the clerk read off is sufficient enough to provide.
And it will be on his bond form that he
Right.
signs, and he'll get a copy of that. Okay.
Yeah, and that's fine.
Anything further then?
And the status conference date I'm looking at right now is May 4th at 2:20. Does that work?
I will be in trial at that time, so if,
Next option would be May 11th at 2:20. Our status conferences are.
that should work, yeah.
Really just a decision about whether or not to have a prelim. So if you don't
Yeah.
want a prelim, you can just send something in.
Yeah.
The waiver, if you want a prelim, send something in and not really.
May 11th is fine.
Okay, we are adjourned. Thank you.
Thank you.
Next up is Omar Reed.
I'm sorry, who did you say is next?
Reed. Reed.
Go on the record in the state of Wisconsin versus Omar Reed. It's 26 CF 645 appearances.
The state appears by ADA Ben Wagner.
Omar Reed appears by attorney William Rakestraw. Mr. Reed is eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, and that's it.
Right, and do we know if we're using the address on the complaint for Mr. Reed?
Johnson Street. What's the address? 7020 Chester Drive. Where's that? Madison, Wisconsin. Do you have zip? 537. Was it? 53751. This case was picked up.
All right, I'll make a finding of probable cause for the charges. And I think they're all elevated to felonies by virtue of the BV repeater. Probable cause has been found. This went out on a complaint and warrant. I don't see a PSA report, and I believe we may have a victim on Mr. Reed's case who wanted to make a statement. They would just need to unmute. And I think the person's trying to unmute. There you go.
Hi. So
All right, can you identify yourself first.
yes, Sukhmita Ali Omar. I am actual the person. I'm his girlfriend, and that the situation was a year ago. So we've been working on him and his mental health and things. He just got out of jail. I just bonded him out for 1,700. So we've been working on him getting a job and doing things the right way. So I really don't know. I did talk to the lady before, and I told her I didn't want to press any charges. She said the state ended up picking it up that it would be great for me to appear today. But yes, Omar Reed is. I'm just trying to get him better right now. So yes, I would not want to push this any farther. He really needs more mental health help than anything, and that's what me and his family is pushing for right now, is to help him get better.
Okay, and because our video screen's quite a ways away, it's hard for me to read the name. Can you just spell that first and last name that you stated so our court reporter can get that taken down?
Yes, yes, sir. Saquita, Saquita, Ali Omar, Aliomar.
Thank you. What's the state's position on bail?
The state's asking for $2,000 cash bail, along with a condition that he not have any contact with Sakita A or any of her children, that he be banned from the 7,000 block of Chester Drive in the city of Madison. The defendant has a history of miscourt and is charged with 2 counts of felony bail jumping. He missed court in Rock County case number 23 CF 1378 on October 30th of 2024, May 23rd of 2025, and November 11th of 2025. He currently has a bench warrant in that case, as this case is being filed. Given those circumstances, I think that some cash is, or $2,000 cash is appropriate here. These are, again, some pretty concerning allegations, and he does have a long domestic violence history, long criminal history, and I think that cash is warranted here. Thank you.
All right. And as far as an outstanding warrant, I guess I'm not seeing anything on my booking sheet. Maybe that's been resolved since the filing.
I think at the time that this was being actually, I know this was reviewed back in 2025. So yeah, it's probably been resolved
You know
since
the
then.
case number from that where there was a warrant?
The Rock County case was 23 CF 1378.
All right, and the defense position on bail?
Yes, Your Honor, I'm gonna ask for a signature bond on this matter. These allegations are from roughly 7 or 8 months ago. I understand that, I mean, they are serious due to the repeater status. However, it appears that his last DV case is at least 6 or 7 years old. He has posted bail in Rock County, Your Honor, and I would ask that another reason for to be granted the signature bond is that he is scheduled for a jury trial in April in case 23 CF 1378. So obviously being held here on cash bail would obviously jeopardize his jury trial case in that county, as well as we have the victim here making her statements in regards to what she feels about what should be going on with Mr. Reed. I believe taking her statements into account, I do believe a signature bond is appropriate here, and that should be what's going on. It's my understanding this was just recently charged. He never got an opportunity to miss court or not show up. So I believe the signature bond is appropriate here, Your Honor.
Yeah, the warrant here wasn't because he missed court.
Yeah.
That Rock County case, there was a warrant. It looks like he posted $1,500 cash bail on that case.
Correct.
So that warrant isn't outstanding anymore. Looks like though he previously posted $500 cash bail and hadn't shown up in that particular case. Attorney Wagner, is there a history with this victim and defendant?
I'd have to go through, let me just check it out here. No, there's been other people involved, but not Mr. Reed, no.
All right. Well, I think Mr. Reed's shown that there's a need for cash bail. He's missed court. He's missed court after posting cash bail. He was out on bail.
Dude, it doesn't matter.
Yep, let your attorney do the speaking, Mr. Reed. He doesn't want you to say anything that gets used against you later on. He's got an extensive criminal record. He's a DV repeater. All of that and the fact that he was out on bail at the time suggests that there's a need for some cash bail. I'll set it at $1,000. I'll order a no acts or threats of violence with Sakita. This is a case that is somewhat dated. There doesn't appear to be a history. It sounds like they've been having contact since, and that's her expressed wishes here today. And I think she's in the best position to know what is appropriate for her. What about time limits for the preliminary hearing, Attorney Rakestraw?
We will not waive those.
Okay, we are adjourned. Thank you, Ms. Aliamar.
$1,000.
Thank you.
Next up is Eric's McCormick.
I'm like, take one, that's my whole life, bro. Find out the 15, she said, I'm not I don't live in my country, I've never been for the tank top. Messed up, man. For 10 months old, I picked it up one day, and he broke that plus the whole line.
Where's next?
McCormick. Great, we'll go on the record in the state of Wisconsin versus Eric McCormick. It's 26 CM 720 appearances.
The state appears by ADA Ben Wagner.
Eric McCormick appears by Attorney William Rakestraw. Mr. McCormick is eligible for public defender representation. We are received a criminal complaint, waive the formal reading, enter pleas of not guilty for misdemeanors.
Right, I'll make a finding of probable cause, get not guilty pleas entered, and I don't see a PSA report. I believe we may have a victim in Mr. McCormick's case who wanted to make a statement on bail. If we could have that person unmute if they're on Zoom. And I think I see him on Zoom. If they wanted to make a
Okay.
statement.
Sorry about
All right.
that.
That's all right. Can you just identify yourself first for our court reporter?
Yes, please forgive me for my voice. I've been under the weather. My name is Rebecca McCormick. I am speaking on behalf of Eric McCormick. He's my husband. I just ask that he is allowed to come home on a signature bond. The stipulation that he goes to treatment at a facility. I do already have the things set up for that facility that he can start as early as Monday for the alcohol addiction. After he had his stroke in January, he has just not been all there as far as when he's drinking, which is making him get drunk faster, I believe. He does have a problem, and I understand that. But I would like him to come home. He's still under neurological care, as well as care under his primary care doctor for the stroke and the brain bleed. I just hope he can come home and we can get him some treatment for that.
Okay, thank you, Ms. McCormick. And is Rebecca the common spelling?
Yes, correct.
All right, thank you. State's position on bail?
No objection to a signature bond, but with the condition that the defendant not use or possess any alcohol. And that he direct no acts or threats of violence towards Rebecca A.M. And that he be banned from the 5400 block of Camden Road.
Your Honor, can I speak?
Is that,
So
is that the
Ms.
address?
McCormick, is it about the address ban?
Yes, I don't agree with the address ban, and he has not had acts of violence towards me or my child. It was against himself. He was suicidal.
Okay, thank you. Any response to that, Attorney Wagner?
I do think that bail recommendation is kind of contradictory. So I would just leave off the ban, the address ban.
Okay, Attorney Rakestraw, any objections?
Oh, no address ban, no objections, Your Honor.
All right, we'll order a signature bond. Conditional be that you not possess or consume any alcohol, to direct no acts or threats of violence towards Rebecca AM.
The last composer, got the shot, hopefully shot.
It's not something I would be ordering. So I don't know whether that's something the jail does, but I certainly don't have any authority to order like a Vivitrol shot or something. I appreciate the request and wanting the assistance in remaining sober. It sounded like maybe you've got some sort of treatment bed set up. So hopefully that's the case. Hopefully that works. Hopefully we're not back here. If we are back here a third time, you know, it might be the time where we need to talk about cash bail if there's continued violations upon conditions of picking cases up. All right, we are adjourned.
Next up is Miguel Ayala, via Zoom for a forfeiture. You did, you paid it?
Yeah, I was gonna say, I got.
Okay.
Wanna get down here? Hey, wanna get down here? Down here. Yep.
Ayala has two cases. Were there two complaints sent over? There's a forfeiture and a misdemeanor.
I've got the misdemeanor, I don't have the forfeiture, obviously.
I'll put out another copy of the misdemeanor. We'll need to be provided with that at some point.
All right, well, let me go on the record in the state of Wisconsin versus Miguel Ayala. It's 26 CM 731 in the county of Dane versus Miguel Ayala. It's 26 FO 530 appearances.
The state and county appear by ADA Ben Wagner.
Miguel Ayala appears by Attorney William Rakestraw. Mr. Ayala is eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading. You guys have. And enter pleas of not guilty to misdemeanors.
Right, and Mr. Ayala, if you can hear us okay, give us a thumbs up in the window there. All right, I see a thumbs up. We'll make a finding of probable cause in the misdemeanor case, enter a not guilty plea. We'll get a not guilty plea entered in the forfeiture case. I don't think we have a PSA report. State's position on bail.
No objection to a signature bond, but with the condition that the defendant be banned from Walgreens.
No objections.
Right, we'll order a signature bond. Condition will be a ban from all Walgreens locations, and we'll be adjourned.
Next up is Chastity Lindsay.
What else? Am I able to leave today? I can leave today?
Hey, Lindsay, what's your step? Yeah.
All right.
Right, we'll go on the record in the state of Wisconsin versus Chastity Lindsay. It's 26 CF 754 appearances.
The state appears by ADA Ben Wagner.
Chastity Lindsay appears by Attorney William Rakestraw. Miss Lindsay is eligible for public defender representation. We are in receipt of the criminal complaint and waive the formal reading.
I'll make a finding of probable cause, enter a not guilty plea to the misdemeanor. The public safety assessment recommends cash bail. State's position on bail.
Well, the state is not objecting to a signature bond, but with the conditions that the defendant not direct any acts or threats of violence or physical discipline towards child victim 1 and child victim 2. The condition that she not to use or possess any alcohol, and that she be placed on pretrial services with alcohol monitoring.
Right, any objections?
None.
Right, and I think the children's names are spelled out fully with dates of birth in the probable cause affidavit. Any reason we can't use like initials or something just to make it more enforceable for law enforcement?
I mean, if they're already in the complaint, then sure, we can use.
The probable cause affidavit, their full name,
Oh.
date of birth, which is a publicly available document.
Sure, yeah, EMW and MJW.
All right. So we'll order a signature bond. Conditions will be that you direct no acts or threats of violence towards EMW and MJW. That you not engage in any physical discipline of either of those children, that you not possess or consume any alcohol. We're gonna make a referral to pretrial services. The deputy's gonna hand the map to their office. But they're on the 5th floor of the Dane County Courthouse. You gotta be there by 10 a.m. tomorrow. It's possible you'll get released in time to get there before 3 o'clock today. If so, great. If not, you gotta come back down town and get there by 10 a.m. tomorrow at the latest. They're gonna equip you with a breathalyzer to make sure that you're not consuming any alcohol. Any questions about that? All right, she's shaking her head no. And what about time limits, Attorney Lakeshaw?
Waive them.
Okay, we are adjourned.
Next up is Damian Smith, via Zoom, forfeiture.
Right, we'll go on the record in the County of Dane versus Damon Smith. It's 26 FO 532 appearances.
The county appears by ADA Ben Wagner.
Right, and you're Damon Smith?
Yes.
Give me a thumbs up if you can hear us okay. All right, so the good news, sir, is you're not getting charged with a crime here. They've charged you with county obstructing, resisting an officer. That's more like a traffic ticket. They're gonna have an offer, and if you want to accept that, then you can just be done with that case. If not, it's not gonna hold you in custody. I think, however, you got a DOC hold that's still in place. That's not anything I can address. You'd have to sort that out with your agent, okay?
Okay.
Is there an offer from the county?
Court costs.
Okay, if you wanted to accept their offer and enter a no contest or guilty plea, you'd have to pay $114.50 in the next 60 days or work out a payment plan if you needed more time. Did you want to accept their offer? Or do you want to contest the charges?
If you can hear me, Your Honor?
Yep.
If I accept it, how much would I have to pay, or would they work that out with me later on?
So if you want to contest it, you don't have to pay anything because we're not setting bail. And it's not going to hold you in custody. And if you got convicted at trial, then I don't know what the judge would order, but that'd be up to the judge. But this is a non-criminal case, so there's no like bail that you have to pay. So this charge.
Tell them I'll accept it. I'll accept it.
Yeah, just so you understand, this charge isn't holding you whether you accept their offer or don't accept the offer, but the DOC holds a different issue, okay?
Okay.
All right, so you want to accept their offer then?
No, I don't.
All right, we'll get a not guilty plea entered. I do need to advise you that if you want to preserve your right to a 6-person jury trial, you need to make a written demand within 10 days of today's date to the clerk of court's office and post $36 in non-refundable jury fees. If you don't do that, then the trial will just be in front of the judge. We've got 5630 Schrader Road, apartment 122 in Madison. Is that a good address for you to get mail?
No, you can send it to Aberg office. I'm actually homeless. I don't have an address.
Okay, we'll update it to the Aberg Job Center. You could also sign up for text message reminders if you're interested. We'll be adjourned for today.
Thank you.
Yep, you're welcome.
The Dominique house.
Sorry, what was that?
Posadowska.
We will go on the record in the state of Wisconsin versus Dominique Posadowska, 26 CF 761 appearances.
State appears by ADA Ben Wagner.
Dominique Posadowska appears by Attorney William Rakestraw. I've been informed Ms. Posadowska does not want public defender aid beyond this point, but she does want our aid for today. She is in receipt of the criminal complaint. We waived the formal reading and enter pleas of not guilty to any misdemeanors.
Okay, and Ms. Posadowska, I want to talk about your right to an attorney after today. Certainly you have the right to an attorney. If you can't hire one on your own, you could reapply with the public defender's office, or you could apply for a county attorney. That's the middle option. I'm going to ask the bailiffs to give you that contact paperwork for the public defender, just in case you need it. I'll make findings of probable cause and are not guilty pleas to the misdemeanors. The public safety assessment recommends a signature bond, state's position on bail.
No objection to a signature bond, but with the condition that the defendant not operate a motor vehicle and that she not use or possess any alcohol. I also believe that pretrial services for alcohol monitoring would be appropriate here. And those are the conditions that we'd ask for.
Right, any objections?
No, that's fine.
Okay, so order a signature bond. Conditions will be that you not operate a motor vehicle at all, that you not possess or consume any alcohol at all, and that you report to pretrial services and comply with their alcohol monitoring. They're going to give you the map to the pretrial services office. That's in the courthouse on the 5th floor. If you get released in time to get there by 3 o'clock today, great. If not, you'll need to come downtown tomorrow, no later than 10 a.m. to check in with them. And what about time limits for a preliminary hearing?
We'll waive those.
Okay, we are adjourned.
Get your board. Report to back.
Next up is Tracy Vallow. No.
We'll go on the record in the state of Wisconsin versus Tracy Vallow. It's 26 CM 727 appearances.
State appears by ADA Ben Wagner.
Tracy Vallow appears by attorney William Rakestraw. It's my understanding Ms. Vallow does not want public defender representation. She is in receipt of the complaint, waive the formal reading, and her plea of not guilty to the misdemeanor.
Right, and Ms. Vallow, we're going to talk about your right to an attorney. So Attorney Rakestraw is going to help you today. If you change your mind, you can reapply with the public defender's office. You can hire an attorney on your own if you're able. If you're not, and you're kind of caught in the middle, you could apply for a county appointed attorney. They've given you the contact info for the public defender in case you need it. Okay, well, we'll address bond in a second here. I'll make a finding of probable cause, enter a not guilty plea to the charge. We don't have a PSA report. State's position on bail.
State's asking for $300 cash, given the misdemeanor bail jumping charge. She'd been banned from the Madison Metro property and was on Madison Metro property when she was contacted by police and found to be in possession of alcohol. So we'd ask for the conditions that she not consume any alcohol, and again, that she be banned from Madison Metro property. She does have some recent failures to appear in. She has bench warrants that have been issued on March 27th of 2025, January 30th of 2025, and November 1st of 2024. So I think there's some risk that she does fail to appear for court and fails to meet the conditions of her bail.
Great. And Attorney Rakestraw.
No objection to cash bail, Your Honor.
All right, well, I think given the history, it's appropriate, and given the statements Ms. Vallow made in the complaint, it's appropriate. I'll set $300 cash bail, order that you not possess or consume any alcohol, and that you be banned from Madison Metro locations. We'll be adjourned. Good luck.
Next up is Demetrius Shepherd via Zoom.
All right, we'll go on the record in the state of Wisconsin versus Demetrius Shepherd. It's 26 CM 718 appearance.
The state appears by ADA Ben Wagner.
Demetrius Shepherd appears by attorney William Rakestraw. Mr. Shepherd is eligible for public defender representation. With the formal reading of the complaint and her pleas of not guilty.
Great, and Mr. Shepherd, give us a thumbs up in the window if you can hear us okay. Okay. See a thumbs up. We'll make findings of probable cause, get not guilty pleas entered to the charges. State's position on bail.
State's asking for $500 cash bail as well as a condition that he not have any contact with Woodman's or Kohl's stores. The defendant had posted $200 cash in each of his two pending cases and had resumed engaging in retail thefts and ignoring the conditions of his bail. It seems that higher cash is necessary and appropriate to ensure that he follows the conditions of his bail and makes it to court.
And Attorney Rakestraw.
Yeah, in light of having cash bail previously, I understand why cash bail would be appropriate here. I believe $500 is too much. I would ask for cash bail in the amount of $300. Mr. Shepard does have strong ties to the community. He's lived here for 17 years, Your Honor, and he's currently on a fixed income receiving SSDI.
All right. I think there's a need for cash bail. I think the defense request for $300 is reasonable, particularly in light of the nature of the charge. I'll set $300 cash bail, order a ban from all Kohl's and Woodman's locations, and we'll be adjourned.
Next up is Ashley Green for a forfeiture. Green. The yellow ones.
All right, we'll go on the record in the County of Dane versus Asha Green. It's 26 FO 535 appearances.
The county appears by ADA Ben Wagner.
All right, and Ms. Green's appearing in person in custody without counsel. Ms. Green, the good news is you're not getting charged with a crime. They've charged you with county obstructing, resisting an officer. So that's non-criminal. It's more like a speeding ticket as far as severity. They are going to have an offer. I couldn't find a booking sheet. Do you know, has she got anything else holding her?
I believe she does, to be just one.
Okay, if you got other holds, that's a separate issue. I can't do anything about that, Ms. Green, but we'll see what the offer is from the county.
The county would offer court costs.
So if you wanted to accept that offer and enter no contest or guilty plea, you'd have to pay $114.50 in the next 60 days or work out a payment plan. Did you want to accept that? All right, and it looks like you've got a body only warrant out of branch 11, so that's gonna have to go back to the judge and have bail set there. Well, it means you can't get out until you have a hearing with the judge. I don't have any authority to touch that case. All right, but you wanted to accept their offer and just be done with this non-criminal case? All right, I'll accept that as a no contest plea to the charge. Order that you pay court costs of $114.50. They're going to give you some info about making those payments and we'll be adjourned.
Thank you.
Yep, you're welcome.
That's.
Right, we'll go on the record in the County of Dane. This is Aileen Spence. It's 26 FO 534 appearances.
The county appears by ADA Ben Wagner.
Right, and Ms. Spence appears in person in custody and without counsel. So Ms. Spence, it looks like you may have a body only hold out of Milwaukee County. So that's going to be a separate issue, but they've decided not to charge you with anything criminal here. They've charged you with a forfeiture carrying concealed weapon charge. So that's more like a traffic ticket or a speeding ticket as far as severity. That is something that could be resolved today. They would have an offer. If you want to accept it, you could be done with that. If you don't, it's not like we're setting bail. It doesn't affect your custody or anything. But you're going to have to sort out that stuff with Milwaukee County. Obviously, I don't have any authority over that. Is there an offer?
Court costs.
Right, so it'd be $114.50 if you wanted to enter a no contest or guilty plea to the charge. Did you want to accept that offer? Or do you want to contest the charges?
I want to accept the offer.
You do want to accept it.
Like, okay, can you kind of explain it a little more to me?
Sure. So if you enter a no contest or guilty plea, I would find you guilty of county carrying a concealed weapon, which is a non-criminal charge. And then in the next 60 days, you'd have to pay $114.50 to the clerk of court's office. If you need more time, you can contact them to arrange for a payment plan. It's not like bail that you have to post up front. But then this case would be done. If not, if you want to enter a not guilty plea and contest the charges, this charge isn't going to hold you in custody. It's not like we're setting bail or anything. You still have that hold in Milwaukee County again. That's a separate issue. Does that answer your question?
Mhm.
All right. So do you want to accept their offer and be done with the case, or do you want to contest it?
I want to accept the offer.
All right, I'll judge you guilty of county carrying a concealed weapon. Order the court costs of $114.50. They're gonna give you some info about making the payments, and then you'll have to sort out your issue with Milwaukee County, okay?
Okay.
Right, we are adjourned.
Next up is Tanisha Love for a forfeiture.
All right, so we'll call the County of Dane versus Tanisha Love. It's 26 FO 533 appearances.
The county appears by ADA Ben Wagner.
And Ms. Love appears in person without an attorney and in custody. The good news, Ms. Love, is they've decided not to charge you with any criminal charges. The charges are county retail theft and county bail jumping. Those are more like traffic tickets as far as severity. I don't see anything else holding you, so I think you're getting released today no matter what. That said, they are going to have an offer. If you want to accept their offer, then you can be done with the case. If you don't, you still are going to get released, but you need to show up for future court dates if you wanted to contest the matters. Is there an offer
Court costs.
for a plea to both counts? There's a.
No, it's plead to one for court costs.
Okay, so Ms. Love, if you want to accept their offer, you can choose which count you wanted to plead to and pay $114.50 in the next 60 days. If you don't want to accept that offer, again, you're still going to get released from custody. Did you want to accept their offer and be done with the case?
Yes,
All right, and do you have a preference as to what charge you plead to?
yes.
Which one?
What you mean? Well, I don't know.
So they're saying if you plead to one, they'll dismiss the other one. There's a county retail theft and a county bail jump. They're both non-criminal charges, but if you had a preference over which one you wanted to enter a plea to, we could do that. If not, I'll just find you guilty of count one, the retail theft, and dismiss count two.
Yeah, can we do that instead, please?
Sure. And then I'll order that you pay court costs of $114.50. And they're gonna give you some info about making the payments on that, okay? All
Thank you.
right, we are adjourned.
Next up is ELAINE Karpinen via Zoom.
Yeah.
Right, we'll go on the record in the state of Wisconsin versus ELAINE Karpinen. It's 26 CM 733 appearances.
The state appears by ADA Ben Wagner.
And we need you on this one, Attorney Rakestraw and Karpinen.
Sorry. Thought it was forfeiture. My bad.
No problem.
Yep. Good. So ELAINE Karpinen appears by Attorney William Rakestraw. Ms. Karpinen is eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, and enter pleas of not guilty to the misdemeanors.
Right, I'll make findings of probable cause, enter not guilty pleas. The PSA report recommends cash bail. And Ms. Karpinen, if you can hear me okay, just give us a thumbs up in the window. All right, I see a thumbs up. State's position on bail.
State's asking for $500 cash bail along with the condition that the defendant not have any contact with Alexandria H. The defendant has some multiple failures to appear, including March 18th of 2026, September 1st of 2023, February 9th of 2023, January 19th of 2023, July 1st of 2022, May 23rd of 2022, February 24th of 2022, August 8th of 2018, June 14th of 2018, August 21st of 2017, July 10th of 2017, January 7th of 2016. And there are more that go back longer than 10 years. I think that some cash is appropriate here, given that record.
And Attorney Rakestraw?
Yes, Your Honor, I understand why cash bail is appropriate, given that history. However, I think $500 is too much, especially considering the charges. I would ask for cash bail in the amount of $200.
All right. Well, it's an extremely extensive failure to appear history. I quite frankly stopped writing them down at about a half dozen. I'm going to set $500 cash bail because we also had resisting when she had contact with law enforcement. I'll order a no contact direct and direct with Alexandria H as a non-monetary condition of that cash bail, and we'll be adjourned.
Yep.
Next up is Lance Vaughn.
We'll go on the record in the state of Wisconsin versus Lance Vaughn. It's 26 CF 756 and 26 CM 397 appearances.
State appears by ADA Ben Wagner.
Lance Vaughn appears by attorney William Rakestraw. Mr. Vaughn is eligible for public defender representation. We are in receipt of the criminal complaints, waive the formal reading, and enter pleas of not guilty to the misdemeanors.
Right, I'll make findings of probable cause in each of the cases, get a not guilty plea entered to the misdemeanor. I don't see a PSA report for either case. State's position on bail.
In 26 CF 756, the state has no objection to a signature bond, but was a ban from home goods stores. And then in 26 CM 397, the state also has no objection to a signature bond, but with the condition that he not use or possess any controlled substances or drug paraphernalia without a valid prescription.
Okay, any issue with those conditions?
None.
Okay, order signature bonds in both cases. In the felony case, I'll order a ban from all home goods locations. And in the misdemeanor, I'll order that you not use or possess controlled substances or any drug paraphernalia without a valid prescription. What about time limits on the felony case?
We'll waive them.
Okay, we are adjourned.
Yep, thank you.
Next up is Brooklyn Martin via Zoom.
Right, we'll go on the record in the state of Wisconsin versus Brooklyn Martin. It's 26 CM 729 appearances.
The state appears by ADA Ben Wagner.
Brooklyn Martin appears by attorney William Rakestraw. Mr. Martin is eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, and enter a plea of not guilty to the misdemeanors.
Right, and if the defendant can hear me okay, just give a thumbs up in the window there. Can you hear me okay? If so, and I couldn't hear any response, and it looks like maybe she's walked away from the window. Ms. Martin, can you hear us okay? If so, give us a thumbs up in the window. All right, I thought maybe she raised a hand, but it wasn't very clear. Perhaps she can indicate to the deputy whether she can hear us. I'm not sure we're, all right, now I see a thumbs up there. All right, I'll make a finding of probable cause, enter not guilty pleas to the charges. State's position on bail.
I think we do have a victim logged in, if I want to make a statement.
Oh, wasn't aware of that. So if we've got a victim who wanted to make a statement on Ms. Martin's case, if you want to unmute first.
Hello, my name is Miguel Meza. I'm the victim.
All right, and Mr. Meza, what did you want to say?
Your Honor, my statement is limited to bail and bail conditions. I do not believe that Brooklyn L. Martin should be granted bail due to concerns for my safety. She has previously harmed me and taken my property, and I am afraid of further harm if she's released. If bail is considered, Your Honor, I respectfully request strict conditions, including no contact with me directly or indirectly, either to friends, family, or third parties. I also request that she be completely banned from Edgewood University, where we attend, and restricted from entering areas necessary to ensure my safety and to stay from a safe distance away from me. Thank you, Your Honor.
Okay, thank you, Mr. Meza. And just for the benefit of the court reporter, I think that's spelled Miguel, MIGUEL, and Meza, MEZA. State's
Yes.
position on bail.
No objection to a signature bond, but with the condition that the defendant not have any contact with MZM and that she be banned from the Edgewood College dorm located at 945 Edgewood College Drive.
Right, and in light of the victim's statements, I don't know anything about a prior history. Anything you can tell me about that, Attorney Wagner?
As far as I can tell, yeah, I'm not aware of any other reported history involving this defendant.
Attorney Rakestraw, any objections?
Your Honor, no objections, just so that Miss Martin knows that if she wants to go get her stuff, she'll just need a police escort. I'm imagining her stuff's still in the dorm.
All right, and I see the thumbs up, and I don't know if you know of a better address for her to get mail.
The address, no, the only address I have is from Edgewood College.
I don't know if we can unmute and whether Ms. Martin can maybe tell the bailiff if she knows whether there's another place that she can get mail that we could send it to. I think you're muted again, Deputy. All right, well, while he's having that conversation, I'll order the signature bond. I'll order no contact, direct or indirect, with MZM and a ban from the Edgewood College dorm. Ms. Martin can arrange with law enforcement for preserve the peace to get any necessary items. I can't hold Ms. Martin without bail, Mr. Mesa, under the law. This is not one of the very few charges that's even eligible for that, and I'm not even aware of anybody actually having pursued that type of procedure in cases where it's eligible. I have to set a bail. I can't set cash bail to protect the public. None of the charges are Act 3 eligible, and I haven't heard about any history. I don't have any real basis to believe she's not going to appear in court. Deputy, were you able to determine a mailing address for Ms. Martin? And if not, I'd suggest she sign up for text message reminders so she doesn't miss future court dates. I think she'll get her very next court date today, though. All right, Deputy, did you get an address?
I did. It's 230 Grand Boulevard, Mayville, Wisconsin. And then she became uncooperative.
All right, thank you, Deputy. We will be adjourned if there's nothing further.
Next up is Rhea Judy.
Right, we'll go on the record in the state of Wisconsin versus Rhea Judy. It's 26 CM 723 appearances.
The state appears by ADA Ben Wagner.
Rhea Judy appears by Attorney William Rakestraw. Mr. Judy is eligible for public defender representation. We are in receipt of the criminal complaint. Waive the formal reading. Enter pleas of not guilty.
Right, I'll make findings of probable cause, enter not guilty pleas to the charges. There's a public safety assessment, recommends a signature bond. What's the state's position on bail?
No objection to a signature bond, but with the condition that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription.
No objections.
All right, we'll order a signature bond. Condition will be that you not use or possess any controlled substances, or drug paraphernalia without a valid prescription, and we'll be adjourned. Thank you.
Next up is Jorge Leon Zavala.
Great, we'll go on the record in the state of Wisconsin versus Jorge Leon Zavala. It's 26 CF 760 appearances.
The state appears by ADA Ben Wagner.
Jorge Leon Zavala appears by attorney William Rakestraw. Mr. Leon Zavala is not eligible for public defender representation. He is in receipt of the criminal complaint, waive the formal reading. That is it.
Right, and do we have a good address on the complaint for Mr. Leon Zavala?
Yeah. Yes, that's correct address.
All right, and sir, I think the deputy gave you the public defender information. Obviously, if you're able to hire an attorney after today, great. If not, you can contact the public defender's office and reapply, or you could apply for a county appointed attorney. That's the middle option. The public defender can point you in the right direction to get that paperwork filed if need be. I'll make a finding of probable cause for the charge. State's position on bail.
State's asking for $500 cash bail, also with the condition that the defendant not operate a motor vehicle, as well as he not consume any alcohol. This is a pretty serious incident, and it's my understanding that the defendant does live in Illinois, so he's not a local resident here. So I think that some cash is necessary to assure his appearance at court.
Okay, and Attorney Rakestraw.
Yeah, I understand that this incident is serious. Thankfully, nobody was hurt. However, I do not believe cash bail is necessary here. Mr. Zavala, from my understanding, has no criminal record. It's my understanding he had been living in the area for a year. Yes, he is listed as living in Illinois, but this is not something where he's far away. That is still within drivable range. I believe with the lack of a criminal record, he should be given a chance to make his appearances at court. As thankfully nobody was hurt in these, even though these are serious charges.
All right, and there's no prior record, is that right, Attorney Wagner?
I'd have to look at the NCIC. He doesn't have one here in Wisconsin, but I'd have to take a look at at statewide or nationwide records to see if there's anything else.
Okay, well, if you want to do that, that's fine. I'll await your response.
Sure. It looks like there's some minor traffic offenses from there's some earlier minor traffic offenses from Cook County, but it does look like there was a charge for ID theft in 2018 from Cook County Police, trespass to a building in 2019.
When you say minor traffic offenses, how minor are we talking? Are we talking civil or misdemeanor?
It's civils, speeding, and I think driving an uninsured motor vehicle, failure to reduce speed, registration issues. Not OWI type of offenses. These other criminal records, I'm not sure what the ultimate result was. Looks like there was a possibly court supervision. I know something that Illinois has, pre-charge type of disposition as a resolution for those. So I'm not sure if that resulted in a conviction or not.
Okay, and Attorney Rakestraw, I'll allow you to respond to all that.
Yes, Your Honor. I mean, of the criminal matters that he brought up that we don't know the final results of, they're all fairly dated. I believe the most recent one is 7 years old, none of which are driving related. So I would still stand with my signature bond statement, Your Honor.
All right. Well, it is an Act 3 eligible offense, so it is a little concerning that he's got a civil driving history for speeding and other related offenses, and here he's allegedly going down the wrong way down the interstate drunk. That concerns me. I was kind of on the fence when it was maybe he didn't have any prior record. I think given he's got some prior record in the driving history, I think some cash is appropriate. I'll set $500 cash bail, order that you not operate a motor vehicle and that you not possess or consume any alcohol. Does he want a preliminary hearing in the next 20 days or 20 days?
We'll waive.
Okay,
So
we are adjourned.
Next up is XAVIER Freeman.
We'll go on the record in the state of Wisconsin versus Xavier Freeman. It's 26 CF 755 appearances.
The state appears by ADA Ben Wagner.
Xavier Freeman appears by attorney William Rakestraw. Mr. Freeman is not eligible for public defender representation. We are in receipt of the criminal complaint. Waive the formal reading.
Okay, and Mr. Freeman, they've given you the public defender information. If you're not able to hire an attorney after today, you could always reapply with them, or you could apply for a county appointed attorney. That's the middle option. We'll make findings of probable cause. State's position on bail.
The state's asking for $3,000 cash bail, as well as the condition that the defendant not have any contact with AMO. This is now the defendant's fourth open case and his third involving this victim. He's previously posted $1,000 and $750 in his open cases. Considering that he's posted that money and still is violating his bail conditions, I think more cash is appropriate given the circumstances.
Wait, and Attorney Rakestraw.
Yes, Your Honor. In light that he has previously posted cash bail, I understand why cash bail is appropriate here. I think 3,000 is too much. Prior, he paid $750 and $1,000. I believe cash bail in the amount of $1,500 is appropriate this time, Your Honor.
All right. Well, there's a need for cash bail. He's just picking up too many cases. The exposure is getting greater and he's allegedly not following specific conditions. I'm willing to set it at $2,000. I think it needs to be an amount slightly higher than what he posted very recently here. So I'll order that. I'll order no contact director and director of the victim, AMO. And what about time limits?
We will not waive those.
Okay, we are adjourned.
Next up is Aaron Owens. This one.
We'll go on the record in the state of Wisconsin versus Aaron Owens Jr., 26 CM 655 and 26 CM 728 appearances.
The state appears by ADA Ben Wagner.
Aaron Owens appears by attorney William Rakestraw. Mr. Owens is eligible for public defender representation. We are received the criminal complaint, waive the formal reading, enter pleas of not guilty to the misdemeanors.
Right, I'll note that one case went out on a complaint warrant, that's 26 CM 655. Probable cause has been found there. I'll find probable cause in 26 CM 728. Yet not guilty, please entered, state's position on bail.
In each case, the state is asking for $500 cash bail, as well as the condition that the defendant not have any contact with Linnell R. That's LENNEL, and that he be banned from the 500 block of Northport Drive. This fourth case, or this new case, would be the defendant's third open case with the same victim. He did have a bench warrant issued on October 25th of 2025, which indicates that he's at risk not to appear at court. I think that cash is necessary in both of these cases. Thank you.
Great, and Attorney Rickstrom.
Yes, Your Honor, I'm not seeing a bench warrant on anything. However, Mr. Owens does have a trial set in May. I understand. That's your jury status. I understand why the state believes cash bail is appropriate. I'm asking for no cash bail in this matter. I'm asking for a signature bond. I understand the allegations are somewhat recent, but Mr. Owens does have strong ties to the community. He was previously employed as a car detailer. His family does live here. His children live here. So I believe a signature bond is appropriate here, Your Honor, in light that he does have open cases with a trial coming up.
All right, and any response from the state?
Again, this is his third open case with the same victim involved here. Even without any kind of missed court, I think this still necessitates some cash bail because he's not complying with bail conditions.
All right. Well, I guess my concern is he was out on an Act 3 eligible offense and then allegedly committed another Act 3 eligible offense by battering the victim that he wasn't even supposed to have contact with. To me, that's a pretty good showing that some cash needs to be on the line. So in 26 CM 728, I'll set $500 cash bail, order no contact, direct with Linnell R, and a ban from the 500 block of Northport Drive. In 26 CM 655, that's not an Act 3 eligible case. I'll set cash bail at $250 and the same non-monetary conditions there. And we'll be adjourned.
Next up is Dylan Viola. Viola? Yes.
Okay, we'll go on the record in the state of Wisconsin versus Dylan Kiola. It's 26 CM 717. Then we also have 26 CF 9 for a bail bond hearing after failure to appear. Appearances.
The state appears by ADA Ben Wagner.
Dylan Kiola appears by attorney William Rakestraw. Mr. Kiola is eligible for public defender representation. We are in receipt of the criminal complaint on the new case, waive the formal reading, enter plea of not guilty to the misdemeanor. 1 second on. Get it on court. Your Honor, he stated he missed court because he forgot.
Okay, and I guess we should make sure we've got a good address. Looks like on the new case, we've got 2835 Egeman Road in Fitchburg.
That address. Say that again. 401 East Dean Avenue. Is that in Fitchburg? In Madison, Your Honor.
All right, I'll make a finding of probable cause in the new case, enter a not guilty plea. There's a PSA report. It recommends a signature bond, although given the failure to appear on March 9th, and it looks like that PSA report says that there haven't been failures to appear in the past 2 years. Perhaps that's something that needs to be updated. Ms. Anderson, maybe you can take a look at that and we can come back to that. The warrant was the failure to appear on March 9th after posting $3,000 cash bail. It looks like that bail has been forfeited. State's position on bail.
In 26 CM 717, the state's asking for $750 cash, as well as the ban from the Town Place Suites in Middleton. The defendant gave a false name to officers, presumably so that they wouldn't find out about his bench warrant. He has a bad record appearing at court. His most recent miss was on that March 9th, 2026 date, as the court had mentioned, where he'd post $3,000 cash in that case. He's also missed court on December 11th of 2024, October 21st of 2024, October 26th of 2023, September 20th of 2022. I think that cash is appropriate here. As the court mentioned, that $3,000 cash has already been forfeited in his felony case. So I think that some additional cash is necessary to assure his appearance. I would ask for an additional $3,000 worth of cash.
All right. And do you have the case number for the failures to appear in October and December of 2024? Because it looks like if those are also countable failures to appear, that maybe there should be 2 failures to appear in the last 2 years that would be added to the PSA.
In October 22nd of 2024, a bench warrant was issued in 24 CF 337. And also in 23 CF 2449.
All right, let me take a look at those. But Ms. Anderson, are you seeing the same failures to appear that the state is for Mr. Kayola?
Commissioner, I did pull up 24 CF 337. It looks like the warrant that was issued on December 11th, 24 was canceled on December 12th of 24, which normally means that it would not be counted by the PSA. Well, I haven't checked everything.
All right.
There was, of course, another warrant from October of 24 that was canceled 3 days later. I think that may be outside the window. They would count that.
Yeah, Ms. Anderson, I think you're muted, but maybe you can unmute. Is it correct that the December one wouldn't count? The October one would, and that leaves us with 2 failures to appear for Mr. Kayola in the last 2 years, in addition to a failure to appear older than 2 years?
I have one failure to appear, the December 11, 2024, and then I have, that was in the past 2 years, and then I have some older than the past 2 years.
And then we've got the failure to appear in 26 CF 9 on March 9th of this year. And is it correct that if the warrant is withdrawn within 2 days, it doesn't count, but if it's something greater than that and withdrawn, it still counts?
Yes, we don't count it if it's a day or 2 after the warrant has been taken away. I'm sorry, I'm using the wrong word, but
Vacated or withdrawn or something?
yes.
Okay, thank you. Anything else from the state?
No, Your
Honor. Anything else, Attorney Rakestraw?
Your Honor, I don't object to $3,000 cash bail on the case that already had the forfeited cash. Seeing that as it's another $3,000, I would just ask for $250 on the new case.
All right. There's a need for cash bail, and I think the state's request is pretty reasonable, all told. I guess I could tinker with the numbers a bit. I'm not going to bother because I think the global amount is appropriate and necessary given the history. So I'll set $3,000 in 26 CF 9 and 26 CM 717, $750, and a ban from the Town Place Suites at Middleton. Let's see, on the felony case.
He does still need to go through prelim on that.
Okay, do you want to prelim in the next 10 days on that?
Yes, please.
Okay, we'll get that scheduled and we'll be adjourned.
Good.
Next is Arinz McCoy.
We'll go on the record in the state of Wisconsin versus Arinz Okoye, 26 CM 721 appearances.
The state appears by ADA Ben Wagner.
Arinz Okoye appears by attorney William Rakestraw. Mr. Okoye is eligible for public defender representation. We are received the criminal complaint, waive the formal reading, enter pleas of not guilty.
I'll make findings of probable cause, enter not guilty pleas to the charges, state's position on bail.
No objection to a signature bond, but with the condition that the defendant not have any contact with Lori Z, that's Lori, and that he not use or possess any alcohol.
Great, and
No.
any issues with that?
No objections.
Order a signature bond conditional be a no contact director and direct with Lori Z, and that you not possess or consume any alcohol. I suppose we should clarify that's not going to be an issue. You'll be able to reside at the address on the complaint still, despite that no contact.
Yeah, once the, no, can I speak? Yeah, after the no contact is expired, then yes.
Okay, well, it isn't necessarily going to expire. It's a
Yeah.
bond condition. It would be in place where you wouldn't be able to have contact with this person until the case is either resolved or the bond is modified. So is there someplace else that you can go or stay for the time being?
Yeah, yes, no, he doesn't, no, so there should be. Okay, yeah, no problem.
So we should be good.
Yeah, we're good.
Yeah, it's not the same address, like,
All right,
Yeah.
I misunderstood what Mr. Okoye was saying.
yeah, no, yeah,
All right,
no, he stays at a different place, Your Honor.
okay, we'll be adjourned.
Next up is Jalen Hessel.
I'm not gonna be your attorney, someone will be assigned to you.
Sorry, what was that?
Hassel?
Council.
Also, I look for bond, signature bond.
Great, cool.
Not bad.
Go on the record in the state of Wisconsin versus Jalen Hassel is 26 CM 724 appearances.
State appears by ADA Ben Wagner.
Jalen Hassel appears by attorney William Rakestraw. Mr. Hassel is not eligible for public defender representation. We are received a criminal complaint, waive the formal reading, enter pleas of not, enter plea of not guilty.
Okay, and Mr. Hassel, I think the deputy gave you the public defender contact info. Sounds like you make too much money to be eligible for one. You're certainly free to hire an attorney on your own after today. If you can't do that, you could reapply with a public defender or apply for a county attorney. That's the middle option. I'll make a finding of probable cause, enter not guilty plea. The public safety assessment recommends a signature bond. What's the state's position on bail?
No objection to a signature bond, but with the condition that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription.
No objection.
Right, we'll order a signature bond. Condition will be that you not use or possess any controlled substances or drug paraphernalia without a valid prescription, and we'll be adjourned.
Next up is this one, Anthony Barker.
It's like. Was that what it was? I didn't even see this turn. Really? Oh my God.
Why?
We'll go on the record in the state of Wisconsin versus Anthony Barker. It's 26 CF 751 appearances.
The state appears by ADA Ben Wagner.
Anthony Barker appears by attorney William Rakestraw. Mr. Barker is not eligible for public defender representation. Mr. Barker is in receipt of the criminal complaint. We waive the formal reading and that's it.
All right, so Mr. Barker, I think the deputy gave you the public defender info. You can reapply with them if you're not able to hire an attorney after today. You could also apply for a county attorney. That's the middle option if you aren't eligible for public defender and can't hire one. I'll make findings of probable cause. State's position on bail.
No objection to a signature bond, but with the condition that the defendant not operate a motor vehicle without a valid driver's license and that he not consume any alcohol.
Any objections?
None.
Okay, we'll order a signature bond. Condition will be that you not operate a motor vehicle unless you have a valid driver's license, and that you not possess or consume any alcohol. You got a question, sir?
Yes, so is my license valid now, or?
I have no idea.
Okay, I didn't know if that can be till after a conviction, or I would say it's probably suspended.
Well, there's such a thing as an administrative suspension. It might get suspended because of the BAC level. But that's something you're gonna want to talk to the DMV or a lawyer about.
So I would say that here, check it. I can see it, but we'll check your license, see if it's that, well, that's what you said. Appreciate it.
All right, and then he has the right to a prelim in the next 20 days.
We'll waive.
Okay, we are adjourned.
Next up will be MR Dixon.
This one.
Well, the record in the state of Wisconsin versus Amari Dixon is 26 CM 726. And then we also have a bail bond hearing in 25 CF 2606 after a failure to appear. Appearances.
The state appears by ADA Ben Wagner.
Amari Dixon appears by attorney William Rakestraw. Ms. Dixon is eligible for public defender representation. We are in receipt of the criminal complaint, waive the formal reading, enter pleas of not guilty to any misdemeanors. 1 second, Your Honor. Your Honor, Ms. Dixon states that she missed court because she got into a car accident. She stated she called her attorney in the court. Nobody got back to her, but she said that's why she missed.
So the court record shows a failure to appear on March 2nd after posting $200 cash bail. It indicates notes in the minutes on March 3rd. The defendant left a message for court staff at 1:50 p.m. on March 2nd. Attorney Benavides emailed with defendant's contact information, warrant to remain until further filings by attorney. March 4, 2026 notes, defendant left second message on court staff phone on 3/3. Defendant must contact attorney regarding missed court date. So those are the notes in that file there. I'll make a finding in 26 CM 726 of probable cause, get not guilty, please entered there. State's position on bail in each of the cases.
In 26 CM 726, the state's asking for $250 cash. In this case, the defendant gave a false name because she had a failure to appear and with warrant, as well as the condition that she not use or possess any controlled substances or drug paraphernalia without a valid prescription. In the felony case, it appears that this is not her first time missing court. There was a bail hearing here at the PSB on January 15th after missing court on January 12th, in which the court ordered $200 cash bail. She then missed court on March 2nd. I think that's more cash is appropriate, so I'm asking for $500 with the conditions that were already imposed.
And prior to the missed court dates, it looks like the PSA in 25 CF 2606 recommended modest cash bail, indicating she'd missed 2 or more times in the past 2 years at the time of the initial appearance. Attorney Rakestraw, your position on bail?
Yes, Your Honor. On bail, I would ask for a total amount of. I understand why cash bail is appropriate based off that record. I would ask for cash bail totaling a total amount of $400 cash, Your Honor.
All right. There's a need for cash bail. It's maybe on the light side. I'm willing to go along with that, because the cash bail wasn't forfeited in the felony file. I'll set $400 cash bail. She'd have 200 that applies to that with the prior non-monetary conditions. And 26 CM 726, $200 cash bail in order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. So by my math, you'd have to post $400 to get released from custody. You got to stay on top of your court dates, Ms. Dixon. You don't have a very good track record here. And then
On the
because of
felony,
the-
could we schedule that for another status conference or should we set up for
Set it for another status, just because I don't know Mr. Benavide, Attorney Benavide's schedule.
okay, we are adjourned.
Next is Matthew Tice.
Alright.
Nice.
Right, we'll go on the record in the state of Wisconsin versus Matthew Tice. It's 26 CF 753 appearances.
The state appears by ADA Ben Wagner.
Matthew Tice appears by Attorney William Rakestraw. Mr. Tice has informed my office that he does not want aid from the public defender's office outside of today. We are to receive the criminal complaint, waive the formal reading, and enter pleas of not guilty to the misdemeanor.
Okay, sir, they've given you the public defender information. If you're not able to hire an attorney on your own after today, give them a call to see if you're eligible. If you're caught in the middle, you could apply for a county attorney. I'll make findings of probable cause and or not guilty plea to the misdemeanor. State's position on bail.
No objection to a signature bond, but with the condition that the defendant not have any contact with KSC.
I suppose I might as well ask, he's got an open case, is that Kevin C does what the condition is to that bond?
Yeah. Yeah, that's the same victim.
Right. And any objections?
None.
All right, I'll go along with it, but Mr. Tice, you need to follow the bond condition, have no contact with this particular person. It's now a condition in 2 cases. You continue to violate that and somebody's going to say cash bail is probably necessary to get your attention, okay? I'll order a signature bond, no contact, direct or indirect with Kevin C, just to be consistent with both bonds in each case. What about time limits?
We'll waive them.
Okay, we are adjourned.
Next up is Jacob Castelli.
This way.
Sorry, what was that?
Castelli, Jacob.
Castelli?
Right, we'll go on the record in the state of Wisconsin versus Jacob Castelli. It's 26 CM 719 appearance.
The state appears by ADA Ben Wagner.
Jacob Kostalik appears by Attorney William Rakestraw. Mr. Kostalik is not eligible for public defender representation. Mr. Kostalik is in receipt of the criminal complaint, waives the formal reading, enter pleas of not guilty.
And they've given you the public defender information, sir. If you can't hire an attorney after today, you can reapply with them. You could also apply for a county attorney, which is the middle option. I'll make findings of probable cause and are not guilty, please. State's position on bail.
No objection to a signature bond with the standard conditions.
And I assume there's no objection.
None.
They will order a signature bond with the standard conditions. That just means make your court dates not pick up any new crimes arising level, probable cause, or harass or intimidate any of the victims or witnesses, and we'll be adjourned.
Next up is Julia Mood.
Right, we'll go on the record in the state of Wisconsin versus Julius Booth. It's 26 CF 762 appearances.
The state appears by ADA Ben Wagner.
Julius Booth appears by attorney William Rakestraw. Mr. Booth is informed officer, he does not want aid from the public defender's office. Outside of today, he is in receipt of the criminal complaint, waive the formal reading. In pleas of not guilty to the misdemeanors.
Okay, and Mr. Booth, if you decide that you can't hire an attorney on your own, you can always reapply with the public defender's office. They've given you that contact info. The middle option is applying for a county appointed attorney.
Is that address correct? Does it need an apartment number?
I've got number 46809 Schrader Road, number 4.
All right, we'll get that updated. I'll make findings of probable cause and are not guilty pleas to the misdemeanors. State's position on bail.
State's asking for $3,000 cash bail, along with the condition that the defendant not have any contact with Cordero H or Cyar J, that's CYAR, that he be banned from the 47 block of Genuine Road in Madison, that he not possess any weapons, and that he has a curfew from 7 p.m. to 7 a.m. This is an Act 3 case. It's essentially a random stranger crime, which shows a risk to the general public. I would request to disclose pertinent information from the defendant's juvenile record under 938.396 as to his appearance history.
Right, and any position on that, Attorney Rakestraw?
Sorry, repeat that.
There's a juvenile history that I asked the court to disclose in regards to bail here.
I would ask for the juvenile record not to be disclosed here for purposes of bail.
All right, I'm gonna authorize them to disclose that information under 969. One of the factors is whether somebody's got juvenile adjudications. I don't know how else I would know about that if it wasn't provided. So as long as it's limited to the prior adjudications and if there were any cases for failures to appear, a lot of the other stuff may be irrelevant. Go ahead, Attorney Wagner.
Sure. The defendant failed to appear twice on his juvenile case 23 JV 204 on September 4th of 2024, as well as December 4th of 2024. KPS were issued on both times. He has a history of failure to appear and resistive behavior towards officers, which indicate that he's not going to appear for court willingly here without cash bail. So I think that $3,000 cash as well as those non-monetary conditions are appropriate.
Okay, Attorney Rakestraw.
Yes, Your Honor. I understand the seriousness of these allegations. However, Mr. Booth is still a very young man. It appears he just turned 18 2 months ago. He should be in school, but obviously other issues have come up. As such, I don't believe he has the means necessary for the bail that is being requested by the state. He does have strong ties to communities. My understanding, he's lived here for 4 years. His parents live here. He's employed at Advantage Solutions where he's worked for 2 months. So Your Honor, I understand the seriousness. I understand why cash bail is appropriate, not $3,000. I'm not going to ask for cash bail in the amount of $1,000 due to his age.
Right, and any response from the state?
Your Honor, I understand that the defendant is a very young man, but these are extremely serious charges that have extremely serious exposure. Armed robbery is a Class C felony, and I believe that's a 40-year felony. That's about as serious as it gets, regardless of his age. So I think that some cash is necessary, along with his history of non-appearances in his juvenile cases. I think that cash is appropriate here.
All right. Well, it's also several Act 3 eligible charges. As I understand the complaint, he pistol whips a juvenile, for lack of a better way to describe the conduct, extremely serious. Certainly seems like an escalation beyond resistive obstructive behavior in juvenile court. We be able to show up for those where the consequences are pretty much next to nothing for those types of charges. It's not like adult court. I've got concerns about whether he's going to show up in court.
Okay.
Yeah, go ahead.
Yes, Your Honor. And that, Your Honor, I understand. That's why I did not ask for a signature bond or anything of that nature. The reason why I believe $1,000 is appropriate here, and the reason why I keep bringing up his age is that I understand there's the Act 3 elements here, and that's why I'm asking, that's why I'm recommending cash bail. But I think there still should be a reasonableness involved here. And if Mr. Booth was older, then I would understand why $3,000 cash bail. He would have an ability to have earned money and earn these things, to have potential cash to do this. He is essentially 2 months past the age of 17. He does not have those kind of resources. So I understand why cash bail is appropriate. I'm just saying I don't think $3,000 is the necessary amount based off the age and his ability to.
And I wasn't suggesting that you were making that argument. I was just trying to say why I don't think this is a signature bond type case and make a record here. No, I think there's clearly a need for cash bail to assure appearance. There's a lot of incentive to not show up on an armed robbery. The dispositions on those are oftentimes confinement and oftentimes prison if convicted. The least I'm willing to set here to protect the public and assure his appearance is $2,000. I'll order that. I'll order a no contact direct or indirect visit. Cordero H and Sayar J.
Yes, Your Honor.
Banned from the 4700 block of Genuine Drive, that you not use or possess any dangerous weapons. And if you post, I'm gonna order pretrial services and GPS to monitor the address ban and also monitor the curfew of you gotta be inside your residence from 7 PM to 7 AM. If we give him the pretrial services information, so Mr. Booth, if you post the bail, you're gonna have to show up to the 5th floor of the courthouse no later than 10 AM on the business day following your release, and get equipped with a GPS so they can monitor the curfew and the address bans as conditions of your bail.
What's that?
Sure.
What city? Not Pittsburgh.
Your Honor, there's a change of address. It's 3025 Churchill Road in Fitchburg. You said it wrong, right? Churchill Drive in Fitchburg, Your Honor.
And is there an apartment or no?
That's the house.
Okay. All right. Well, I appreciate you bringing that up, Mr. Booth, because we don't want you to miss court notices. Because if you post the bail and you miss court, the statutes say the bail shall be forfeited. The statutes also say that the bail should be forfeited if you violate conditions of bond or pick up new charges. So I'm not just trying to keep you in custody here. So hopefully you're able to post the bail and hopefully you comply with the bond conditions and show up in court. All right. What about time limits? Should we just get it set for a premium?
Yeah, I'll set those.
Okay, we are adjourned.
Next up is Devontae Smith.
Right, we'll go on the record in the state of Wisconsin versus Devontae Smith, 25 CF 2611 appearances.
The state appears by ADA Ben Wagner.
Devontae Smith appears by attorney William Rakestraw. Your Honor, I do not have any information as to whether Mr. Smith is eligible for public defender representation or not. If he seeks our services, he will need to reach out to my office to determine eligibility. We are in receipt of the criminal complaint, waive the formal reading, enter pleas of not guilty to the misdemeanor.
Okay, and Mr. Smith, they've given you the public defender contact info. If you need their resources, you got to give them a call to get evaluated. You're certainly free to hire an attorney later on if you're able. If you're not, and if you also don't qualify for a public defender, the middle option would be applying for a county appointed attorney. I'll make findings of probable cause and or not guilty pleas to the misdemeanors. There's a public safety assessment report that recommends a signature bond. State's position on bail.
No objection to a signature bond, but with the condition that the defendant not direct any acts or threats of violence towards DFD and MAS.
DFD and MAS.
Yes.
Right. Any objections?
None, Your Honor.
Okay, order a signature bond. Conditions will be that you direct no acts or threats of violence towards DFD and MAS. Because you do have a felony charge, you have the right to a prelim in the next 20 days. What's your position on that?
We'll waive.
Okay, we are adjourned.
So.
Next up is Jermaine Peoples.
Yeah. Right, go on the record in the state of Wisconsin versus Jermaine Peoples. It's 26 CF 757 appearances.
The state appears by ADA Ben Wagner.
Jermaine Peoples appears by attorney William Rakestraw. From my understanding, Mr. Peoples does not want SPD representation outside of today. He is in receipt of the criminal complaint, waive the formal reading. That's it.
Okay, so Mr. Peoples, they've given you the public defender information. If you change your mind, you can give them a call and get evaluated, but you're certainly free to hire an attorney on your own if you're able to. Okay, yeah, no problem. Yep, Attorney Rakestraw is going to help you today. He's a very experienced lawyer. I'll make findings of probable cause, state's position on bail.
No objection to a signature bond, but with the condition that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription.
Any objections?
None.
Okay, order a signature bond. Condition will be that you not use or possess controlled substances or drug paraphernalia without a valid prescription. And then you're gonna have the right to a preliminary hearing in 20 days. Attorney Rakestraw, what's his position on that?
Let's waive that.
Okay, we'll be adjourned.
Yep.
That's everyone's.
Sweet.